Well, hello everyone. James Manson here, constitutional lawyer, coming to you from a vacation destination. I've been out of the country for a couple of weeks following the big court hearing that took place back on the 13th and 14th of February. As I'm sure some of you may now be aware, we received the court's decision today in the prorogation challenge case. I'm sad to report that we were not successful. The application was dismissed by Chief Justice Crampton, and the court rendered a 96-page decision. It's well over 300 paragraphs long, so it will take some time for us to go through the decision to see what are the fine points and what are the fine details that the court rests its analysis on. But I did want to at least reach out to everybody and sort of give a little bit from the court's decision so that you can understand a little bit about the reasons for the dismissal of the application. The first thing is that there were a number of preliminary issues that the court was dealing with, and the Crown was arguing that should result in an immediate dismissal of the case. I won't get into those issues right now, but suffice it to say that we were successful on all of those preliminary issues, which allowed the court to get into the actual heart of the matter and consider the case on its merits. And that was good for us, of course. Naturally, one wants to have the decision, made on the basis of the merits and not on a preliminary issue. So certainly, the court was very thorough in examining all those preliminary issues and deciding that yes, all of the preliminary issues were basically not hurdles for the court, for us applicants either to overcome. So that was good. Getting into the merits, however, really, I think the whole thing boils down to the court's conclusion that basically Prime Minister Trudeau, in making the decision to prorogue Parliament, giving those reasons back on January 6th, that in fact those reasons did not demonstrate that he exceeded the scope of his authority as Prime Minister to prorogue Parliament. I think that the court here does sort of recognize that some of the reasons given might have been a bit troubling. However, the court goes on to say that there were other reasons given by the Prime Minister in his press conference, and it was difficult to disentangle the troubling reasons from the non-troubling reasons. And ultimately, the court wasn't convinced that the Prime Minister, again, exceeded his authority to prorogue Parliament. So really, that's the long and short of it. I can also say that in the circumstances of the case, the court was not inclined to order costs payable by my clients to the government, which I think also recognizes that this was a significant matter of public interest, and that therefore there ought not to be any costs payable personally by Mr. McKinnon or Mr. Lavranos against to the government. So that would be that's at least something. We are certainly studying the decision now. It'll take some time to go through it and to see whether there are any serious issues that we think may warrant an appeal. Certainly there will be a possibility of an appeal to the Federal Court of Appeal. I understand that many of you may question whether that has any usefulness given the fact that we are already on March 6th and we've heard rumblings of perhaps an early election being called anyway. Like I've said many times, this whole case isn't really about an election. It's about the proper use of the Prime Minister's power to prorogue Parliament. And so there may be a useful appeal which might help in, again, establishing what those limits are and whether the Prime Minister acted outside of his authority. Again, the court here today concludes that in fact the Prime Minister did not exceed his authority. We will again be studying the decision, ask ourselves whether or not there are any serious issues that we can identify that might be considered errors that might warrant an appeal. So stay tuned for that. Anyway, I would like to thank everybody for their continued interest in the case. Certainly, it's been a privilege and an honor for me to, help bring these issues to light and advance the case before the federal court. On behalf of my team at Charter Advocates Canada, and also the people at Justice Centre for Constitutional Freedoms. Certainly thanks to everybody for your interest. Thanks to everybody for all the donations that we've received. Naturally, if anybody is minded to make donations, you're welcome to do so. Go to jccf.ca, sign up, and every little bit helps, as it always does. But stay tuned for further updates from us anyway. And meanwhile, you can also read the decision yourself at I think it's on the website at jccf.ca already, and you'll be able to read it for yourself. Of course, it'll take you a little bit of time. It's 96 pages long, so if you want some light reading tonight, go for it. As for me, I'm going to go for a swim, and I will talk to you guys all soon. Thank you. Bye.